Right, looks like we have quite a number of people with us, so we'll kick off our event. Good evening, everyone, and welcome. My name is Nevena, and I'm the General Manager of the Information Rights Project. I'd like to thank you for taking the time to join us and be part of this important briefing. Tonight's event focuses on something everyone here feels passionately about: Australia's speech suppression laws, how they operate, how they affect us, and what they mean for our country. We saw these laws justified in the name of national security and social cohesion, but they do raise serious questions about proportionality, transparency, and the long-term impact on freedom of expression. These laws and others like them are something the Information Rights Project stands strongly against. As soon as they were announced, we organised a petition against them, campaigning firmly on the side of freedom of expression and free speech. The bill that was put up was not only un-Australian, but it went against the very idea of justice and fairness that we as a nation hold dearly. Nearly 10,000 supporters like yourselves agreed and signed on to petition. In less than 48 hours, we also organised and wrote to the SNAP Parliamentary Joint Committee on Intelligence and Security, which was accepting submissions for only a very short window of time on the Combating Anti-Semitism, Hate and Extremism Bill 2026. The timetable given afforded Australians and organisations like ours only a number of days to consider and respond to a wide-ranging package that amended criminal, migration, customs, and firearms legislation and looked to expand background checking regimes. So we reached out and invited you, our members, to provide written input and to guide our submission. We received more than 1,700 responses in less than 6 hours. Despite the variety amongst our respondents, the submissions displayed a really high degree of consistency with the concerns raised. Numerous submitters expressed alarm that the bill introduced vague and subjective offences, with liability turning on how speech might be perceived rather than if actual harm had occurred. You, our supporters, repeatedly warned us that this approach departed from established principles of law and posed serious risks to freedom of expression and due process. Ours was one of the many thousands of submissions received, but the bill was eventually rushed through our Parliament. Shortly after, we set up a petition to repeal the speech suppression laws, and we appreciate and thank everyone who's already signed on to that. To help us delve deeper, we're really pleased to be joined by two people who bring deep experience and perspective on this issue. First, Greg Barnes SC, Information Rights Board Member and one of Australia's most respected voices on civil liberties and human rights. Then we'll hear from Gabriel Shipton, founder of the Information Rights Project and brother of Julian Assange, on his perspective on these laws. Tonight you'll hear from both of them, and then we'll open the floor for a Q&A toward the end of the session. You're very welcome to submit questions throughout the event using the Q&A function, and we'll do our best to get through as many as possible. And just a note that this event is also being recorded so we can share it with the supporters who weren't able to make it this evening. With that, I'll hand over to Greg Barnes to share his legal expertise with us now. Thank you very much, Greg.
Well, thank you, Nevena, and thank you to everyone. I want to acknowledge that I am tonight on the traditional land of the Mwinana people in Nipaluna. And I want to pay my respects to elders past and present and emerging. This bill, and lawyers see legislation every day, and some of it badly drafted, some of it well drafted, most of it middling. This would have to be one of the worst pieces of legislation from a drafting perspective that one has seen in recent years. And I don't blame the parliamentary drafters. They were given an impossible task by the government. And they came up with legislation which is going to be subjected to a whole raft of litigation, inevitably because of the way in which the legislation works. Now, what's unusual about this legislation is this, and I said this the other night on a Zoom for David Shoebridge, the Greens senator, who's been terrific in his opposition to this and joined with us, and that is that normally lawyers like to be able to give their clients advice, and normally they like that advice to be as certain as possible within the realms that lawyers can do that, and understanding that, you know, police and others can exercise discretion in the way in which they deal with matters. This is legislation where you have to default to a position where you say, I don't know about slogans. I don't know about what constitutes hate speech. So if I just have a look at the bill, I won't go through all of it because it's fairly lengthy, but if we can just have a look at, thank you very much, guys. We might have to enlarge it a little. This is page 6 of the bill. I don't know if that can be enlarged. That's great. Thank you. So I wanted to look up, and this is a typical example, right? You'll see here the definition of religious official and spiritual leader. Now, there is no definition of religion. There is no definition of what it means to be a spiritual leader. Now, you might think it's self-evident, but we live in a pluralistic society where we have a range of religions, we have a range of other forms of spirituality. What does it include? What does it exclude? You know, who decides? But that's fairly typical of this legislation. If we can go now to page 9, just a few pages on, this is the really alarming part. This is the part of the bill that deals with prohibited hate groups. So you'll see there that the objects of the bill is to protect the Australian community or part of the community against social, economic, psychological and physical harm. Psychological harm. Now, again, psychological harm has a certain meaning if you're talking about personal injuries law or you're talking about victims of crime. We understand it. But what does psychological harm against a group in the community mean? I mean, it you know, it boggles the mind, or the mind is boggled by it, because it's just so difficult to know. One can understand social harm to some extent, economic harm if, for example, there are attacks on businesses, and physical harm. One can understand those. But what psychological harm means is anyone's guess. If you just go down the page, please. Now, the government can make a group a prohibited hate group, and it has to. It does so. It has to get advice from the Director General of ASIO, the Minister for the AFP, who's responsible for it, has to then. I think doesn't have to, but should speak to the Leader of the Opposition, and then it goes to the Governor-General. But one of the key purposes of prohibited hate groups is that they have alleged to have committed hate crime. And hate crime is defined, if we can go to the next page. Sorry, keep going. We'll get to it. Okay, so we'll just stop down here and then work through. Now, you'll see here the definition of hate crime. And hate crime includes current offences in the Commonwealth criminal law, which deal with threatening violence or incitement against groups or members of groups. So if we go to the next page, the hate crimes, though, is also, and this is in subsection 2, if you see that there in the middle of the page, A hate crime is also conduct that involves publicly inciting hatred of another person because of the race or national or ethnic origin of the target. Now, you'll notice here, there's no protection here for same-sex community, no protection here for on the basis of other forms of disadvantage, disabilities, etc. So it is purely focused here on race, national, or ethnic origin. Now, bizarrely, a hate crime is not only where you commit a crime under a Commonwealth law. You'll see down the bottom of the page here, it says if you commit a crime under a state law, and they name the state laws down there, New South Wales, Victoria, Queensland, I think over the page, if we can just go over the page, you'll see other states mentioned, South Australia, ACT, WA. If you commit an offence against one of those state laws, that can also be a hate crime for the purposes of the Commonwealth. Yet those state laws are all different. So I might do something in Western Australia which is lawful, but if I do something in New South Wales, it might be unlawful. So I could be committing a hate crime in New South Wales for the Commonwealth purposes, but not a hate crime in Western Australia. Again, go figure. So you'll see here that, again, hate crime is not designed in a way that makes it easy for people to understand. Now, if we can just go to, just stay on that page. Now, you'll see here a hate crime also is conduct which causes serious harm to people, causes serious damage to property, and the motivation is race or national or ethnic origin. Now, that's easier written than it is proved. You might have a person who has a variety of motives. They may not like the person who runs the local bottle shop. They may not like the group that meets at a particular church hall. But that might be personal. That could be a range of reasons. How do you show that that person has engaged in or threatened to engage in because of the person's race or national ethnic origin in those circumstances? Or the target of the property is associated with that person. Now, again, what does targeted property mean? And I'm not going to go into it in detail, but you can see the problem. Does that mean, for example, a synagogue, a mosque? Probably. Does it mean a store, a shop owned by a Muslim person? So it's the imprecision that makes it so difficult to advise people. If we can just, sorry, I meant to go back up. If we can go back up to the definition of advocates, because I've had a lot of queries about this, so we keep going there. So just to stop you there, the definition of advocates. It says an organisation advocates engaging in conduct constituting a hate crime. This is very important for groups, protest groups. An organisation, by the way, can be part of a larger organisation, formal or informal, which mirrors what's in the terrorism laws. So it can be a group that regularly meets on a Saturday morning to protest against the genocide in Gaza, but it's an informal group. Or it can be a well-organised group that has a constitution, something like the Information Rights Project. Now, you'll see here that advocating hate crimes is if you counsel, promote, encourage or urges engagement in conduct constituting a hate crime, or you praise the engagement of conduct constituting a hate crime, or conclude or conduct that would constitute a hate crime if engaged in Australia, where there's an unacceptable risk that such praise might have the effect of leading a person, regardless of the person's age or mental impairment, to engage in conduct constituting a hate crime. Now, that last part is really difficult, because that means that you could have a person with a mental impairment, having acted for many people with mental impairments. They do things for a whole variety of reasons, and they're not necessarily incited, particularly with 10-year-old kids, for example. But one of the problems is, what does it mean to promote, encourage, or urge engagement in conduct constituting a hate crime? If I go to a rally and I say that death to the IDF, now, is that to be taken literally? Obviously not. Some might mean that, but it's against an institution. It's not against an individual. But is that conduct constituting a hate crime? Other slogans are the same. The problem with slogans is this, that they mean many things to many people. And one of the problems with this legislation is that the reasonable person test, in other words, who is it that judges whether or not the particular conduct is offensive, etc. Normally, it's just a reasonable person, the average Joe. A reasonable person would think that saying that all blacks should be killed is obviously racism, it's inciting, etc. Here, what happens is the reasonable person is the person with the characteristics. So, for example, if I am a hardline supporter of Al-Qaeda, or I am a hardline supporter of the Netanyahu government, what I think is reasonable might not be what other people think is reasonable, what the community thinks is reasonable. I might be easily offended. So that's another problem, that the reasonable person is actually a reasonable person, but only with the characteristics of the person that is alleged to be upset. Now, the last thing I wanted to say on that, and I'm going to give you an example from South Africa. If anyone's from South Africa here, they'll know what I'm talking about. But this illustrates the problem with trying to legislate in relation to protests and what is said at protests. In South Africa, there is an apartheid song from the apartheid era that says, "Kill the Boer." Taken literally, it would mean kill white farmers and kill any white farmer you see. The higher courts in South Africa have recently ruled that it's got a contested meaning, and that, in fact, it means it's a protest song. It's not to be taken literally. But what we've done in Australia is that we have said, and we've got governments doing it at the moment, and it's frightening. We've got governments saying that we're banning From the River to the Sea. We're banning Globalise the Intifada. Now, that's essentially saying that these are attacks and inciting attacks, that there will be attacks on Jewish Australians, which is palpable nonsense. It's palpable nonsense that these are slogans, again, with contested meaning. But you're getting, what you're getting now as a consequence of the government's legislation and the fear that's being generated is incitement against people who are using those slogans. Look at the pile-on of Grace Tame. 25,000 people signing a petition saying she should be stripped of her Australian of the Year. This sort of hatred being generated by the very sort of legislation that politicians are bringing in, they say, to improve social cohesion. I'll be very quick because Gabriel's got to come on and talk. If we can just scroll down a little, and I'll tell you where we need to get to. Thank you. So Right. So, no, sorry, no, keep going. No, you've got it, you got it. Okay. Have a look up the top there. The AFP minister is not required to observe any requirements of procedural fairness in deciding whether or not the AFP minister is satisfied for the purposes of the section. Now, it's a very short provision and it's extreme, it's undemocratic, it's a clear breach of the rule of law. Procedural fairness means, as many of you would know this, so I won't spend much time on it, that I am entitled to be heard. I'm entitled to be heard because my interests may be adversely affected. And that's why, for example, if the government cancels your visa, generally speaking, they'll give you notice that they're going to cancel it. Under this legislation, you and your organisation could become a prohibited hate group simply on the say-so of ASIO, so you wouldn't know what they were telling the minister, or any other information that the minister seeks to use. That could be after lobbying from particular groups. And you're not entitled to have a say. Sorry, you're now a prohibited hate group. Why? I'm telling you because you come within the legislation. Well, can we argue about that? No, I'm sorry. Now, of course, becoming a prohibited hate group has all sorts of consequences for people. So the lack of procedural fairness is just extraordinary. At least, for example, in the anti-terror legislation, where they have control orders, which of course are orders that can be made even if you haven't committed a crime. It was done in the Jihad Jack Thomas case many years ago. At least there, you've got to say. This says a minister could do this overnight. Now, that sort of provision is a recipe for corruption. It's a recipe for lobbying by interest groups that don't like a particular another group. The last thing I'd say about the legislation is this, that this legislation is built on the anti-terror legislation. And those of us who oppose the anti-terror legislation said one of the reasons we opposed it was because we said it introduces concepts which ought to be unlawful, but which, once used here, will be used elsewhere. And we've seen that. We saw that with anti-bikie legislation, and we're seeing it now with this legislation. So what's next? We're going to use elements of this legislation to prohibit environmental groups. We're going to use it to prohibit organisations that are standing up for whistleblowers. Now, people say, "Oh, that's extreme." It's not extreme. That's where you adopt these principles in one form of legislation. You think that's a great idea. Let's just cut and paste and use it over here. That's what happens. So I'll just say this lastly. The states and territories, or particularly the states, not all of them, but most of them, are now moving to ban particular slogans. You can expect to see that there will be High Court challenges. Now, it is likely, in the view of most lawyers, that some of this legislation will get knocked off, and some of the state legislation which bans slogans will get knocked off because it's disproportionate. But we do not have a right to freedom of speech in this country, and that's one reason why this organisation exists. You only have what's called an implied freedom to political communication. That's on a case-by-case basis. So you do not have that right to freedom of speech. I'm going to end it there, and we're going to hear from Gabriel, and then I'd be happy to take questions. Thank you.
Thanks very much, Greg. And judging by the many questions that we've received in the chat, you have shared a lot of information that's got people thinking, and we look forward to resuming the Q&A shortly after Gabriel speaks. So next we're going to be hearing from the founder of the Information Rights Project, someone who I'm sure is very familiar to people with this chat. We're going to welcome Gabriel in a second. I'm just going to pluck him out from our extensive viewer list. Gemma, can you see Gabriel?
Hey, I'm here.
Oh, fantastic. I'll just spotlight you for everyone. Gabriel, thank you for joining us tonight.
Yeah, it's great to very, very much an honour to be with everyone here and to follow on from Greg Barnes SC, who's one of the leading experts in this field, I would say. So we're very lucky to have him with us speaking on this legislation. And just thank you for everyone who's here. I know probably a lot of you here who have been supporting this organisation since its launch, but also supporting the fight to free my brother that we undertook for many years. And yeah, I just can't stop thanking all those people who are involved in that enough. So thank you so much, me, my family, for everything that you contributed. If you were there with us, and thanks for coming along and continuing the fight as well. So I just wanted to maybe talk a little bit about how these laws will affect just ordinary people out there in Australia. I'm not even talking about politically active people or people who are hold strong opinions or anything like that. And I think the case of Serena Tanuri is one that it really exemplifies of how these laws can just go totally wrong. So Serena was a 26-year-old or is a 26-year-old. It's called the Butt Dial case. If anybody who hasn't heard of it, you can go and Google it to see Serena's lawyer talking on it as well. But it's called the Butt Dial case. Serena Tanuri is a 26-year-old intellectually disabled woman. She's on the NDIS. She works at Bunnings. And what happened to Serena was that she accidentally pocket dialed Mandy Saker, a Jewish nutritionist and author, and she got through to Mandy's voicemail. And there was a lengthy voicemail. Obviously, when you call someone by accident, there's no voice or anything like that. And so there was a long voicemail left on Mandy's phone, a blank voicemail. There was some background noises. Serena's lawyer said there was some bed creaking, some snoring. And so Mandy actually reported this to police and said that she felt immediate fear and nervousness. She said those sounds resembled gunshots to her. And so what we saw next was officers from Operation Shelter, which is a special anti-Semitism task force, arrest Serena Tanuri, this 26-year-old Bunnings worker. They arrested her at her Meadowbank home for this threatening butt dial. And she was charged with using a carriage service to menace, harass, or offend. And her lawyer, Osman Samin, it was charged first, asked questions later. That's what he said. And he dubbed it the butt dial case. Now, these charges were eventually dropped after about 4 weeks. But this case, I think, exemplifies of how these laws could and would be used into the future. And actually, the case of Serena, I think, sends a very strong message to anybody who's actually thinking of, I guess, what the conflation here is criticism of Israel being anti-Semitic. And so anybody who's criticizing Israel could possibly be accused of inciting fear or nervousness in somebody could have Operation Shelter at their door arresting them. And I think this really speaks to the authoritarian nature of these laws, that they are so Kafkaesque that you could wake up one morning with a knock on your door. It will be people from Operation Shelter, the police from Operation Shelter. You won't know what you've done. You won't know what you've been charged with. You'll be taken down to the police station. You'll be arrested. You'll be charged for leaving for a butt dial phone call. And I think this really harks back to that era that Kafka lived in, and really speaks to what Australia is becoming now. And that case, I think, is a brilliant example of how these laws have and will go wrong. And in fact, these laws that actually went through, the government actually wanted stronger laws. They wanted racial vilification parts in there that would have made them even stronger than those ones that were able to be applied to Serena, except they didn't get support. They didn't have bipartisan support for those parts of the law. So I think for people who don't know, it's important that we give a bit of context to how these laws were put through. And they were put through in the wake of a terrorist attack down at Bondi Beach. And obviously that was a horrible event, and we feel for all the families and individuals who lost their lives there. I personally knew some people who were injured in those attacks, so it was very close to me as well. But time and time again, governments use these kinds of events to launder really, really bad laws that impinge on our rights as Australians. And Greg brought up the anti-terror laws that were put through in the wake of 2011 and so forth. Of September 11 and so forth. And so these laws were put through and rushed through in a similar context. And we can look at how they were put through. There was a special sitting of Parliament. Parliament was called back during the summer break. There was very little time. There were over 7,000 submissions from the community around these laws. The community was given 3 days to submit these, and the government had 3 days to consider these submissions. And so that's a very, very short amount of time to really give any rigor to these laws. So it's very, very obvious to anyone out there that this horrible legislation was being rushed through and being laundered by this horrendous massacre. And so I'll just catch up with my notes a bit here. So what we've seen now is Australia is actually a global outlier when it comes to freedom of expression. We are one of the world leaders in the Western democracies of speech suppression legislation. In the United States, you have, what is the gold standard of free speech laws, which is the First Amendment. Canada has the Charter of Rights and Freedoms, which Section 2B protects freedom of expression. Even the United Kingdom has a Human Rights Act and common law protections going back centuries. The European Union has Article 10 of the European Conventions of Human Rights, and the United Nations, the UN Declaration of Human Rights, which was actually one of the drafters of that was Herbert Vere Everett, who was an Australian, has Article 19 that everyone has the right to freedom of opinion and expression. So Australia is really becoming the outlier when it comes to Western democracies. And I know Greg touched on this before, that we don't have any explicit protection in the Constitution. There's that political speech part, and only that narrow implied freedom. And there's no statutory bill of rights at the federal level. And so these laws really threaten us more than they would in these other countries, because we don't have any of those fallback protections. And so I think that chilling effect that we see, that people like Serena Tanuri's arrest, it's not just on journalists or whistleblowers. It is on our conversations with each other that we will see the effect. I've already have seen this amongst the people that I talk to, some of our more wealthier donors who are now very much afraid to make donations to us because of these laws, is having very much a chilling effect on our organisation, but on also all the conversations that we are having with the people in our circle. There is a lot of fear out there that people could lose everything through these laws, and so there is a real chilling effect that is going on here. And so Greg, I think, really summed up who controls these sort of definitions around these groups, these banned organisations. I wanted to touch on that, but I think Greg covered that really well, that there is actually no community input, no independent review, no due process. It's ASIO advises the minister consults with the Attorney General, the opposition leader gets a briefing, but for a group to end up on this list, there is no due process or community consultation, which is we should all be very, very scared about that, I think. And so I just maybe want to take, in summary, that it's not, these laws are very bad, but I think what the effect that they will have, there will be a silencing effect that I spoke about, but I think there will be a binding effect. There will be a resistance network that is formed against these laws, just like we saw with the demonstrations against the Israeli Israeli President Herzog, who came out to Australia. That we will, as Australians, we will resist these laws, and there will be these networks that form that push back. That these examples like Serena Tanuri will outrage people, will make normal people want to take action, and I really have faith that that is going to happen. And I think it is a real sign that these laws came down when they actually did. It's a sign that the Free Palestine movement was getting enough traction and enough acceptance in broader Australia that these laws needed to come down, because let's face it, we all know that these laws are squarely aimed at the Free Palestine movement, that they are going to be used against the Free Palestine movement at some point in time. And I think it was those hundreds of thousands of people marching across the Harbour Bridge, Australia recognising Palestine at the United Nations. These milestones that were happening in Australia really put the wind up the forces that don't want us to acknowledge them, that want us to continue this, very bad relationship that we have with Israel. And it's laws like this that tell us that a policy is incredibly unpopular, because when a government or a power can no longer sell a policy to the public, they use what they have at their disposal to convince the public or coerce them into liking the policy. And clamping down on speech is the first thing. Clamping down on protests, like we've seen last week, is up there as well. And so I think we're making a lot of headway, and we just can't really stop on these issues. And so there is, I think, a glimmer of hope that we are making progress, and that these networks of resistance will continue to form. So on that note, I wanted to everyone, I think we Nevena mentioned earlier that we have a petition out there, a petition calling for the repeal of these laws. Please go on and sign that if you haven't already on informationrights.org. And if you have already signed it, please share it amongst your friends. Forward the email to 10 people if you can, and make a small donation, because it's your donations that really keep this organisation going. Without your small donations, our average donation is around $40. So it's without your small donations, we can't keep on doing this work. We don't take any money from government or any big donations, so that we can stay independent and we can keep doing the work that we need to do with information rights, like supporting whistleblowers, like the Four Corners whistleblower, Marcus. Things like that is really hard to do if we're captured by larger donors or institutional donors. So thank you so much for your support. And I think probably it's time to go to some questions.
Thanks so much, Gabriel. A lot of questions and comments coming through, a lot of reactions from our supporters. Thank you for sharing with us. It has come to our Q&A time, so thank you everyone who's had the chance to submit one in the chat or via the Q&A. Greg, a lot of them have a legal bent to them, so I might start by directing them at you. We have a comment first from Justin saying, my year 10 English exam was drafted better than this and I didn't pass. So I think that speaks to the general level that people are seeing. We had a question earlier on when you were speaking to the definitions, Greg. Someone asked, why not just have inciting hate against a person? Why do we need groups given that they will always change?
Well, it's a very good question. And the problem is, what is the group? Who's in the group? I mean, the other real issue with it, of course, is that incitement is restricted in this legislation. It doesn't protect people on the basis of sex, gender, etc. So it's quite narrow. But it is a difficulty because defining the group is a difficulty. I mean, there may be, for example, let's take this example of because it's topical, of the Jewish community in Australia and people born in Israel. There would be some, for example, the Jewish Council of Australia and other progressive groups who would not take offence or would not feel threatened by particular slogans. But there would be other groups in the community who would. So when we come to the reasonable person test with those characteristics, which one is it? Is it the person who is supportive of the Netanyahu government, or is it the Jewish Council of Australia? Which person? So, I mean, an ethnic group could be said to be Jews in Australia, but it's not. It's not a homogenous group. It's a group with varying views. Same with the Muslim community.
Greg, we've also had a comment here that says, I think this speaks to the heart of the matter regarding these laws. We are legislating for people to feel threatened in any way, a totally subjective issue without providing any valid proof. Surely there must be some onus on the so-called victim to show evidence of a threat, not just a feeling. We can't legislate for people's feelings. This is something that we've had a lot of feedback about, Greg. How do you feel? How do you feel about feelings now counting as incitement from a legal perspective?
That's the problem with psychological harm. Look, there is case law, and there is legislation which deals with hurt and humiliation, as there should be. But I think the difficulty here is that this legislation is designed to chill people. And I don't mean that in a positive sense. It's designed to make people cautious about what they say. Gabriel, his usual eloquent fashion, put it earlier that, we face in this country a serious threat to freedom of speech. And the threat doesn't have to be the closing down of speech. It's that people think twice. Now, sometimes we all should think twice before we say something, but people have to think twice about what last week was quite reasonable to say, but the government is now saying you be careful. And that, of course, is one of the problems. The other thing I'd very quickly say about prohibited hate groups is, of course, it allows the minister to look at your past. It's retrospective. Oh, I see that this group in 2024 said this at a rally. I'm going to take that into account. I mean, the sort of stuff you normally leave for courts, and normally you don't make legislation retrospective for a very good reason, because you're criminalising conduct that at the time was lawful and people thought was lawful.
Greg, someone has also asked, why this legislation when we already have state-based anti-discrimination legislation?
Very good point. I mean, what else can I say? Very, very good point. I mean, the Commonwealth also has laws in relation to incitement in the Commonwealth Criminal Code. I mean, this is, and Gabriel pointed out as well, this is what happened after 9/11. We had this rush. We've got to have laws. We've now had over 80 variations of the anti-terror laws. You watch these laws. There will be variation after variation after variation, particularly what lobby groups might say.
Mm.
One of the points that Anne Toomey has made, who's no radical, but I think, the preeminent constitutional scholar in this country, or certainly right up there, made this point in the conversation recently where she talked about the fact that the problem with the hate speech registration is that it can be used very easily to shut down your opponents. You could just imagine governments, particularly governments in places like the Northern Territory and Queensland that sort of have a fascist tinge, which will get me into trouble, but true, close groups down. We're going to make you a prohibited hate group. Why? We don't have to tell you. We've heard from ASIO that you're dangerous. Done. That's how dangerous it is. You wouldn't. This legislation wouldn't pass muster in Canada, or probably, despite all of its faults, the United States, because the First Amendment would protect that freedom.
Greg, someone has also asked on that same bent, and Gabriel, this is something you mentioned when you were speaking, is do these laws violate international law, in particular the right to freedom of expression under the UNHR Charter?
I'll give that to Gabriel. I'll have a question off.
Well, they are actually against the UN. Article 19, they go directly against Article 19 of the UN Declaration of Human Rights. In terms of the international law or how that is applied here in Australia, I can't really answer that question. I'm not really informed on that, but they do, if you do a comparison of this bill, they actually violate quite a few sections of the UN Declaration of Human Rights. So it's, like I said, it's like, all of a sudden Australia is now the world leader in Western democracies of speech suppression, which it's just flabbergasting. I thought we would be, really thought we were a stronger, more robust society than this.
Some of you might, I want to put my hand up and say I only remember this as a very small kid, but I have a very good friend who was involved in the anti-Vietnam demos back in the late 60s when he was at Monash. Made a really good point the other day. He said, we used to shout the most outrageous slogans, about Americans being baby killers and Australian soldiers being baby killers. But there was never, even in that conservative era, never any attempt by governments to say, well, you're going to go to jail for that, or we're going to make that hate speech. And that was in pretty conservative times. So that shows you how dangerous it is, and it illustrates the point Gabriel's making.
Greg, bringing together a couple of questions about this, we've had a few people ask something to the effect of, given that Zionism is a political ideology, not an ethnic group or a religion, can we legally exclude criticism of Zionism and Zionists from prosecution under these laws?
I don't think you can rule it out. I don't think you can rule anything out. I mean, there was an argument I saw, I think, in The Age this morning, a piece, or it might have been the New York Times, a piece arguing that Zionism is, means different things to different people. It's not always political. I'm not going to enter that debate, but I don't think you can rule it out. I think that, and that's the problem with this legislation. You just got to say to people, and I had people recently, a group of people approach me about what they could say at a rally. And I had to say to them, and you hate saying this to people, I had to say, look, I think you should default to a conservative position for the moment. And I think on Zionism, you run the risk. I think it's outrageous, but you run the risk of, Tony Burke turning around and looking at your organisation and deciding that you're a hate group.
Mm.
And that if you're a member, by the way, you'll go to jail.
Yeah, I think Lydia Thorpe actually tried to move an amendment to this bill that criticism of Israel, the IDF and Zionism is protected political speech. And that amendment was actually voted down 43 43-12, both major parties opposed it. So she tried to carve out criticism of Israel and the idea. And then I think, wasn't it David Spears on the ABC actually asked the Attorney General, Michelle Rowland, if accusing Israel of genocide would come under these laws if Jewish Australians felt intimidated, and she couldn't answer the question, right? Like, she couldn't answer whether, if a group accused Israel of genocide, that they wouldn't be a banned group. So I think that was really telling.
Yeah,
that she wasn't willing to say that.
Well, and then she went on to say, Gabriel is absolutely right. She was asked again, I think, by Spears, if protesters are saying Israel is engaged in genocide or condemning Israel, saying it shouldn't exist, and it led to Jewish Australians feeling harassed or intimidated, they could be banned. She replied, if those criteria are satisfied, then that is the case. I mean, that is extraordinary that an Attorney General, the first law officer, meant to uphold the rule of law, would say that. That's one of the most dangerous statements made by a politician in this country for many, many years. A politician who's actually the first law officer of this country.
Greg, we've got plenty more questions, but in the interest of time, we might just wrap up on something to look forward to in the future. And it's something you've written on quite extensively in the past. A supporter has asked, what about promoting a federal human rights bill? Does that sit within federal, state and Commonwealth possibility?
Well, we already have a Human Rights Act in Queensland, Victoria and the ACT. Of course, we should have one at the Commonwealth level. The Labor Party, it's part of their platform, or it used to be. But I see, extraordinarily no movement on it. This is the only democracy in the world that does not have a Human Rights Act. One of the problems with the Human Rights Acts in the states and in the ACT, I think the same, is that they can carve out, they can say, oh, this legislation, the Human Rights Act doesn't apply. But it's better than nothing. So, you cannot take freedom of speech seriously in a country unless you have a Bill of Rights and unless it's constitutionally enshrined, as it is in the United States. I mean, there's a lot wrong with the United States, and people say outrageous things. But in a way, that's the point of democracy. It's noisy. People say stupid things. Of course, there are limits. There are always limits. But there ought to be very, very broad scope given. And the point about freedom of speech is that it does make some people uncomfortable, but that's the very point of it. You want to support, Israel's genocide in Gaza. You have to expect that people will disagree with you, and they'll do so very vocally, and they'll do so with some serious rhetoric. That shouldn't be an issue. I mean, it was the same with apartheid. When Australian sporting teams were participating in South Africa, and South African teams were coming here, there was enormous coverage, and same with the Vietnam War. Blah 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 blah. Why is it an issue? Why is it a problem in a democracy? I mean, Bondi, as Gabriel said, was a terrorist act. There is no link, by the way, as I understand it, between what those two did, the terrorist act committed by those two people, and the broader and the Palestinian movement. No link at all. They were ISIS. But politicians have used this to cave into a particular lobby and a particular news group. They've shown how they will jettison freedom of speech, a cherished right in a democracy. They will jettison it because they've got they're jelly-backed, collectively jelly-backed.
Gabriel, before we close up, anything you'd like to share as a closing note?
Oh, that was a great way to finish, Greg. I just reiterate exactly what Greg said. It's I think, shows there's a real lack of confidence in our political leaders that they need to put these laws in order to avoid a political conversation that we're all having these days. And also, I want to just reiterate to everyone, please share the petition and sign the petition if you haven't done it already. If you can forward the email to 10 people, that would be so good, and spread the word, and donate, donate, donate. Thank you very much, everybody.
Thank you so much to everyone who's joined us this evening, everyone who's commented, everyone who's signed the petition, everyone who's donated, and everyone who stays engaged with our organisation. We are here because of you, and our work can only continue with you by our side. Greg and Gabriel, thank you so much for sharing your time and expertise. As you can see by all the claps and the love hearts, there is a lot of appreciation to both of you and the enormous effort you're putting into fighting this terrible legislation. A recording of this event will be made available via email tomorrow. And if you have any other questions or want to stay engaged with this campaign, please feel free to reach out. Enjoy your evening, and thank you again. Good night.
Thanks, Nevena.
Thank you.
Thanks, everyone.
Cheers.